University Commonwealth Law School. My name is Christian Johnson. I'm the Commonwealth Professor of Law and Business Advising and the Director of our Business Advising Program. And it is a pleasure to welcome you here today to talk about the issues and activities with respect to business interruption insurance and exactly what's been going on. We have two extremely capable and exceptional presenters today, both of which who are on the firing line with respect to the actual litigation that's going on in this issue. In other words, both of these attorneys have a dog in the fight, for want of a better expression. So I think you're going to get the latest updates on what's going on and really where the important issues are and how this is working. Our first speaker is Scott Cooper, who's a partner at Schmidt Kramer here in Harrisburg. Scott's one of the finest plaintiff lawyers in the state and has been very successful with respect to business interruption insurance cases here in Pennsylvania. He's also a great friend of the law school, being in one of the law school's very first classes when we first opened the Harrisburg campus. He's currently also the chair of the Board of Advisors for the law school and also teaches a course on civil procedure for the school as well. He's an active member and prior president of the Pennsylvania Association for Justice. And I love this next comments because they're running out of superlatives for Scott. He was named as a Pennsylvania super lawyer, a Reader's Choice attorney by Harrisburg Magazine, a top lawyer by the Central Pennsylvania Business Journal, a select lawyer by Susquehanna Magazine, and named the best lawyers in America. And so we've effectively run out of adjectives to describe how terrific Scott truly is. I'm just giving you a bad time, Scott, as we talk about that. He is a frequent lecturer and has published extensively on litigation and participates widely in various lawyer associations here in Harrisburg. Kevin McNamara, our other speaker, presenter today, is a partner at Thomas and Hafer here in Harrisburg. Kevin concentrates his practice in general civil litigation and insurance law over the past 25 years. He's an expert on issues involving business interruption insurance litigation. Kevin is a frequent speaker on insurance matters at seminars, continuing legal education programs, and training sessions for claims professionals. He's also served as a mediator. He's been appointed as a member and then chair for multiple two-year terms as a Dauphin County arbitrator. Kevin is currently serving his second term as a hearing officer for the Disciplinary Board of the Supreme Court of Pennsylvania. Karen is married with 3 children and is a veteran of the United States Air Force. And right now I'm going to go ahead and our first presenter will be Scott, and then he will turn the time over to Kevin. We're basically going to allow the speakers to present their issues, and remaining time we'll be taking any questions from the audience via chat. And so please go ahead and send your questions. I'm not sure how much we'll be able to get to them, but the extent we're able to, we'd like to answer your questions as well. So Scott, please go ahead and get us started.
Thanks, Dean. Thanks, Kevin, for participating, and thanks for asking us to do this. It's obviously an honor and a privilege, having grown up with Widener. So as far as the program itself, the way we're going to do this is Kevin and I are going to go back and forth with almost like a point counterpoint, initially starting out with just a background on monies and how this came about and what the policies are intended to do or not intended to do, and then get into the different arguments that are being raised by both sides in the cases and talk a little bit. Then we'll talk a little bit about, in general, what I think people will see is that Pennsylvania is almost, I think it's fair to say, we're probably one of the more, from a plaintiff standpoint, successful cases as opposed to others around the country where I think you'll see the insurance companies have won probably 90 to 95% of the cases, give an update on the current cases. And then if you have a claim or know anyone who has a claim, what to do to preserve the claim, and also what to request and what to look for in the policies. So with that, we'll start. If anyone wants a copy of the PowerPoint, feel free to shoot me an email. Just as far as when this popped up in 2020, at the time, the insurance companies had surpluses. And what I think Kevin, you'll hear from Kevin, is a lot of this issue, the business interruption, is really something that was never really intended to happen, to be covered under these policies. But things got shut down in March. One of the things people call about, and this is not necessarily business interruption, but just in general, a lot of companies gave money back on premiums last year and even this year because people weren't driving. And a lot of the state regulators told insurance companies, you should give back a certain amount of premiums for that year. I usually just show this, that State Farm had no problem giving back $2 billion in auto premiums. So in covering these claims, whether or not the insurer, or at least our argument is, in covering these claims, so what the policy says is what the policy provides, and whether or not it was intended or not, that's not the business problem, that's the insurance company's problem. And they are getting like $9.9 billion of premiums a year for this coverage. Now, Kevin's going to talk a little bit about what the problem potentially going down the road and about these policies themselves.
Yeah, thank you, Scott. Generally speaking, a little bit of insurance basics are important to understand some of the underlying issues here, because the industry, when these claims started coming in the spring of last year, the industry responded very quickly to what was an unanticipated problem. And basically, this type of coverage is property coverage for policies that cover risks to buildings and their contents. It has added protection for business interruption when a covered event affects a building. That's when business operations are interrupted, then this coverage triggers. Generally, insurance is designed to cover these losses that are unpredictable and unpredictably impact individual policyholders in separate incidents. It is really not designed to cover events like the pandemic, which strike the bulk of the insured population at the same time. So if you are, for example, a regional insurer that's heavily invested in Pennsylvania and providing coverage to small businesses, and all of a sudden you find yourself beset with claims from every single one of them, it is a very different situation than when a storm hits an isolated area. Insurance essentially is they use risk pooling methods to spread the risk across the entire insured population, so that when one small segment or one individual is hit with a claim, then the company and the industry is prepared to do it. Insurance companies are all about planning. They're about loss history. They're about anticipating what might happen so that they can charge appropriate premiums based on the risk, and then can reserve appropriate funds of money to deal with these risks, which again are designed to deal with things that happen in isolated areas to small subsets of the insured population. The irregularity of the pandemic risk is something that was not planned for. There are those reserves and surpluses that Scott referred to a few minutes ago, those are to cover everything, not just business interruption. And there's some people, the agencies that study this type of thing, you can see the loss estimates there, 3.1 billion to 11.5 billion per month. You can imagine how this type of an exposure would devastate, particularly, well, it would kill the industry if it was done on a national basis, all 50 states. The industry is simply not prepared to deal with this type of loss that hits every small business or even large businesses, because there are a lot of big businesses that have also presented claims. It doesn't, it's not peculiar to little businesses, but you can see the total monthly premiums. Those are Pennsylvania figures in property policies to cover all risk related to these types of commercial insurance. And then if you compare that to the 3.1 billion to 11.5 billion per month in exposure, you can see how this would quickly create a crisis in the insurance industry. Thanks.
Kevin, I've got just a quick question for you. How do you deal with the obvious and superficial question that, well, this happens to industries all the time, you know, where they make a misjudgment or they don't adequately protect themselves, and that's just the way life works. Is that something that people throw out at you and ask you about?
Well, number one, I don't think anything like this happens all the time. Pandemics, we're talking about once a century type risk, virtually impossible to plan for in terms of collecting an appropriate premium, because if you're trying to figure out when you need an extra, I don't know, 100 or 200 billion in reserves, you can't collect premium over time to plan for something that's only going to happen once in 100 years. So that it is not the type of thing that can be easily planned for in terms of making sure that reserves are set and that premiums are charged appropriately. But all that being said, the industry did plan for dealing with pandemic risk by fashioning a policy that does not cover damage that or events that don't cause physical damage to property, and also by putting a clearly worded exclusion. But I'm getting ahead of myself to try to comprehensively answer that question.
Terrific. Thank you.
You bet.
Thanks, Kevin. And getting into the main issues now, what I'm going to go through is the different types of coverages, and then what the main arguments that we've been making. And then Kevin's going to explain, like he was just talking about, the different defenses and exclusions that are in the different policies and how the policies have been issued. The first one, and there's different types of coverages in each policy. Generally, in a commercial policy, you're going to have a commercial property insurance policy that generally will play for accidents, like a car goes through the door and causes an actual physical damage, or the building blows up or something like that. What business interruption insurance coverage is losses and income that while the business has been closed because of the physical or the whatever the property damage was. So that's generally what the business interruption, that your business has been interrupted by some physical loss of or damage to your property. So it kind of flows from the main part. And generally, what the policies will say, and this is the crux of the main argument, is they'll say, we will cover for business interruption because of physical loss of or damage to the property. And we'll talk a little bit about the arguments in a little bit. Some policies actually say direct physical loss of or damage, and there's some cases that have been decided that that's a more restrictive policy, and I think Kevin would agree that there's various arguments to be made, but there's some policies that are probably written a lot better than other policies. There's probably some policies where you could argue it's more ambiguous than a policy that has direct physical loss of or damage, and they have like a specific exclusion that says virus or pandemic or something like that. But we'll talk about that in a minute. As far as what you can seek for, generally your losses and damages are going to be for like rent or lease payments that you can't make because you lost business due to the loss, relocation costs if you have to relocate employees depending on your business, employee wages and taxes, loan payments. It's not really going to cover like for flooding and things like that, but it's really direct losses that you have. One issue, which I think you're going to see if there are going to be payments, this may be getting a little bit ahead, and Kevin, I don't know if you've had this come up yet, is whether if a business took a PPP loan and it was basically forgiven, does that count as an offset off of the person's losses? Because then a lot of people arguably may not have had any losses. But I think right now everyone's just trying to make sure whether there's even coverage before you get into all these other issues.
Yeah, Scott, when that issue has come up, what I've basically done is pleaded it as a defense, but none of the cases that I'm handling have gotten to the point where the impact of the PPP loan or other government programs. There's a bailout program for restaurants that is either on the books or in front of Congress now that they're talking about to try to deal with these things outside of the insurance context.
So that's something down the road, but it is something to keep in mind if you're pursuing the case. I've had a lot of businesses that initially we were representing them, and they've called and said, well, we had $50,000 in loss. We recovered $48,000 in PPP and it's forgiven. We don't even want to be bothered by it. Whether or not it's an issue, I could definitely see both sides to it, but that's something that's going to be probably litigated. But there's the business interruption coverage, and then there's what's known as civil authority coverage. And civil authority coverage is generally a more limited coverage that pays for a lot of things that business interruption would pay for, but it's basically while your business cannot operate due to a government order. So basically what happens is if there's some property loss or damage or issue, and it's generally limited to it has to be within a mile of your business and you cannot operate it, then you generally can get the same type of losses for civil authority coverage just for a shorter period of time. Generally, I think it's sometimes 30 days, sometimes 60 days, but that's a more limited period of time. But there are certain limitations that you have to be totally unable to use the property. You have to have, again, the physical loss of or damage. And one of the issues that, and we'll talk about in a minute, that's being litigated is whether the presence of a virus is actually a physical loss. So arguably, if your business is located within a mile of Harrisburg Hospital, and then you were shut down by the government orders, instead of having business interruption, can you now argue that you have civil authority coverage? And it must be covered by the damage has to be covered under the policy. So those are generally the two issues that have been pursued. There's other limited issues, what's known as contingent business interruption, which is really supply chain issues that gets a little bit more complicated, and it really isn't what the main arguments have been over so far. But that's the general two areas that we're looking at, the business interruption and the civil authority. But the one thing that is common to every case, and this is our argument, is that in order to even get the ability to potentially have coverage, you need a physical loss or damage to the property. And what we're arguing in our cases, and we've been successful in a couple of cases in state court in Pennsylvania that are up on appeal, which we'll talk about, is that it's really physical loss or damage, that the loss of use of the premises is what is meant by that. And then damage is actual physical damage. Kevin will explain the counter in a minute, but we're saying that being unable to use your property as is intended to be used for a business, whether it be a dental office, a restaurant, a car dealer, and being totally shut down, is a physical loss of the premises. Then you have a physical damage as a result. Then also, if they're not entitled to the business interruption, at the very minimum, they should get civil authority, because under civil authority, basically, I think at the beginning, it's been established by now that the virus was everywhere once the government orders came. So it'd be really hard to argue that the virus is not physical, since it's a virus, and that it's located within a mile of your business and that you were shut down by the government. That the policies are ambiguous at best, and at least under Pennsylvania coverage, the policy, if it's ambiguous, as long as there's, the way I've kind of presented it, as long as both sides have a reasonable interpretation of the policies, the insured is supposed to get the coverage. So when we're making an argument for a business, as long as our argument is not totally crappy and totally unreasonable and makes no sense, it's almost the tie goes to the runner, being the business. In some policies, and Kevin will, I'm sure, will talk about this, there's virus exclusions. And some virus exclusions are written really poorly, like it basically says bacteria as opposed to virus. Some policies don't even have a virus exclusion. So for instance, in one of our cases, Erie does not have a virus exclusion that refers to contaminants or microbiomes or virus. So once you get into that main part of the policy for the coverage, you don't even have to deal with an exclusion. There's also a reasonable expectations argument that the insureds are making. Basically, well, we're a business. This is, whatever the insurance companies intended, they could have written the policy a different way. When a person buys this coverage for their business, they're expecting, hey, if we can't make money because we're shut down, that's what we buy insurance for. None of these have really been ruled on other than the physical loss of use, which I'll talk about in a minute. And then another issue is, what were the provisions in the initial policy? If we get to the issue of the physical loss of use or damages recoverable, some policies were issued for certain businesses without virus exclusions. And then over the years, the virus exclusion was added. And companies are supposed to provide like the update that most people get every year, where it says, you get your renewal and it says these provisions were added to your policy and stuff like that. 99% of us don't read the insert. You basically take it, you say, all right, what's my premium for the next year? End of story. If the companies did not provide at least a notice that this was being added to your policy, an exclusion or change in some fashion, this even applies in auto policies and things like that, then that would be something you could argue is invalid. There's a case from the Third Circuit going back 15 years, Van Buskirk v. Highlands Insurance, dealing with a auto edition, and the court said that because they didn't receive proper notice, they could get the coverage. So those are different arguments that are being raised. They're out there. Really the main ones right now, which we'll talk about in a few minutes, is in the cases is whether it's a physical loss or damage. So now when I file the complaint, now we have Kevin telling me I'm totally wrong.
Yeah, and in this particular circumstance, I will tell the audience that Scott is totally wrong on every one of these points. Starting with direct physical loss of or damage to property, typically the triggering mechanism in these policies is some form of direct physical loss or damage, and in non-COVID context, that generally means that something hit the building, a storm hit the building, some other physical force acted on the building to damage it or to destroy its functional use. So, and again, generally speaking, these property insurance policies are written in such a way where it is crystal clear that you must have some physical repairable damage to property or there's no coverage. And that is because business interruption is measured by a concept called period of restoration. Insurance, as I said at the beginning, insurance companies are all about predictable risk and trying to plan for when loss occurs and charge appropriate premiums for it. So in the case of how long does a business interruption claim last, the policy answers that question with this concept of period of restoration. So a business income loss claim lasts for as long as it takes to repair, replace the property, or for the insured to resume business at another location. It is in the context that we have here of the pandemic with COVID, there's no way to repair or replace a functional property that has only been either shut down due to a government order or due to some fear that an outside force in the form of a virus is going to act on the property. So in virtually every case that I know of, in every policy form that I know of, there is some form of requirement of physical loss or damage to property. And every insurer in every one of those situations stands initially on the principle that there's no physical loss or damage to have triggered a claim. In 2006, the insurance industry recognized the possibility that pandemics could occur and could have an impact on insurance. So in 2006, after the SARS scare, which did not result in a pandemic, but was a sharp enough event for the industry to realize that something needed to be done, virus exclusionary language was put together and inserted in policies in a number of different ways. The typical exclusion, although there are different forms of this, but the typical exclusion excludes all loss related to virus or bacteria that could cause illness or disease. It's about as straightforward a statement of we don't cover this as there can be. There have been some assaults on the exclusion. Certainly in Pennsylvania, none of them have been successful. There are somewhere between 30 and 50 decisions in PA that have basically said that virus exclusion in its traditional form, it is clear, it is unambiguous, and it excludes loss. It's essentially a backstop to the physical loss or damage requirement and is a plain statement that there's no coverage for virus-related claims. With respect to government orders and whether or not they're covered causes of loss, they're actually not. Every one of these policies has each individual coverage, the business income, the extended business income, the civil authority coverage, it all has a triggering requirement of a covered cause of loss, and a government order is not a covered cause of loss. The most of the claimants bar here has things in reverse, where they have an order that leads to a loss. But typically, in every type of coverage, when this comes up, the loss precedes the order, and that's particularly true in the civil authority coverage. And an order to control virus is not a direct physical loss. There is no actual physical loss that is immediately related to an order, except, as Scott mentioned, perhaps this concept of loss of use, which I believe doesn't pass muster when you read the entire policy and apply the period of restoration issue. There were, as time has gone on, these claims have been in litigation for over a year now, and there's been an evolution of pleadings. The initial pleadings, particularly in virus exclusion cases, were that our business did not have virus on premises. It was very clearly pled in a lot of cases, and it was pled to escape the reach of the virus exclusion. Since then, the pleadings have changed to basically say that the virus is ubiquitous and it's everywhere, and the risk of it's everywhere, and that the virus exclusion does not apply for various other reasons. But the position that the entire insurance industry has taken, and which has been accepted again and again and again by courts reviewing this, is that the virus and the order are not separable. The order was triggered, the one and only reason for the order is the virus. The purpose of the order was to control the spread of virus. And so any argument that the loss was caused by an order and not the virus distorts the reality of the situation, is that the virus is at the root of this entire situation. Civil authority coverage, most cases, there were only a few cases nationally that have found that there is coverage here, usually based on only the absence of physical loss or damage. But even in those cases, many of them have recognized that civil authority coverage can't really survive because civil authority is generally triggered when a covered loss occurs away from the insured premises. So if you operate a hotel and the property across the street is struck by a natural disaster and becomes condemned and unsafe, the local government may order that nobody can get within a block of that damaged building. That's the situation where civil authority coverage is generally triggered. You physically cannot get into your premises because of a government order that restricts access to your business because damage that occurred somewhere else. Civil authority coverage does not apply here because in most of these cases, the order of civil authority did not completely preclude access to premises. In the case of restaurants, takeout and delivery operations were allowed to continue. I had a case involving hotel properties, and hotels, their operations were not suspended at all. And so civil authority coverage does not apply unless access is completely precluded by the order of civil authority. The last point on this page is on both state and national levels, the overwhelming weight of authority cannot be disputed. That many judges nationally, many judges in Pennsylvania have reviewed these issues, and the weight of authority is, if I said it was, I think Scott's numbers were 90 to 95%, and I think that's pretty spot on. And it's meaningful in this context that if you have court after court after court and judge after judge after judge, and including 4 federal circuits now that have looked at this issue and found there's no coverage, I will tell you that there is no specially distinguishing feature in Pennsylvania law that would make policy interpretation here any different. And so I think what we've seen in forms of a trend is what should happen in Pennsylvania.
And obviously I disagree, but that's why we keep going on with these things. So a couple things that you probably out there are going to want to know. Kev, we've been talking a lot about these cases and stuff. There's actually a website that the University of Pennsylvania, Professor Baker there has put together where he started to keep track of these cases going back since the beginning. And I'll give you the site. It's cclt.law.upenn.edu. And basically, or if you just Google University of Pennsylvania, Baker, COVID, it's a litigation tracker that basically is always kept up to date, and it basically has every case or probably 99% of the cases. Another two other articles, since we're talking about law school, that have recently come out, and it's not in the materials, is if you're like an insurance geek like me, you always look at Couch on Insurance. And one of the Couch articles, the insurance companies have been citing, but there's actually a fallacy in it, and someone did in the Torts and Insurance Law Journal. I'll give you the site and then the title. It's 56 Tort and Insurance Law Journal 621, fall 2021, and it's titled Physical Alteration Fallacy, Its Origins and Consequences. And then in the Connecticut Insurance Law Journal, volume 27 at page 185, there's an article about what the insurance companies, when this started, how they went into denial mode right away. But those are the only areas that I've seen that have two articles that have been published so far, if you're looking for citations and things like that. As far as court,
Scott, before you go on, that Insurance Law Journal article, if it's the one I'm thinking of, one of the things that has been brilliantly done by the plaintiff's bar here is to attempt to backstop these claims with what might be represented as learned treatises. The author of that article criticizing Couch on Insurance, because it was cited in one of the appellate cases that I have before it was published. The author of that is a plaintiff's advocate who I know for certain is in, I forget what the count is, but he or his firm is in at least 30 cases, one of them $750 million case, business interruption case. So definitely read all of these things with a grain of salt and understand who is authoring them.
and for what it's worth, I did not cite that one. I cited the Connecticut Insurance Law in my brief, but but looking at the cases, and Kevin, there's one case that is not on the slide that you may want to read, because Kevin mentioned about the natural disaster kind of opening up the policy to getting these coverages. There is a case early on in the pandemic that has nothing to do with business interruption that the state Supreme Court decided, our state, and that's one of the arguments we're making on these cases. It's titled Devito versus Wolf, and that dealt with businesses suing, saying that the governor had no authority to basically shut down the businesses during the pandemic. And what our Supreme Court in Pennsylvania said is he did have the authority because this is basically a natural disaster. They didn't interpret specific language in a policy, but they did say this was akin to a natural disaster. So that's one of the arguments that we've raised. And I'll go through these cases real briefly, is basically Hungarian. That's at least as far along as the cases I've had. This is a dentist from Pittsburgh who was shut down, and we filed a lawsuit in Allegheny County, and the judge found in our favor and said that there was coverage, and that that there was not a virus per se exclusion. That was a microbe exclusion or something, but found in our favor. That case is currently on appeal to the state superior court, and it's being argued in Pittsburgh December 14th. It just got listed. So if you're looking for a case, and like Kevin said, and I agree, 90 to 95% of the cases around the country have been lost by the businesses. Probably in Pennsylvania, the same thing, although fortunately we've had two that we've been successful in. The second one is the Mcmiles Grant Street versus Erie case. And if you're familiar with Pittsburgh, Grant Street Tavern is literally like right across the street from the Pittsburgh courthouse. And it's a tavern. They were shut down, and we filed a claim on their behalf against Erie. That case does not have a virus exclusion or anything. It's purely statutory. We were successful on that, and right now that case is up on appeal. The briefs have not been filed yet, but that's going to follow on Garion. The one thing we did do in Grant Street is, since the one issue that I think everyone agrees on that needs to be decided by the appellate courts is physical loss or damage, is we asked, since there's no virus exclusion in that case, we've asked the Superior Court to take immediate en banc argument to at least decide that issue, so we don't have all these different cases going up on appeal. But that was just recently filed. Tambellini really is going up on more of a, if you're a civil procedure person, on consolidation and coordination. That's the main issue right now. The only other main one I think to mention is Erie Insurance. What the federal courts did is they did what's called a multi-district litigation. So any cases against Erie that are in federal court are automatically being transferred, and this is throughout the country, to Judge Hornick in the Western District of Pennsylvania on a multi-district litigation, and they're going to be moving forward there. There really has not been a lot of movement on that, but with that, and I agree, Kevin will mention a couple of his cases, I'm sure. The overwhelming majority of Pennsylvania cases that have been ruled on by the trial courts in state court or federal court have found no coverage for one reason or the other. Would you agree, Kevin, right?
Yeah, for sure. And essentially there are two different tracks. There's that state court of common pleas track, and then there's the federal track. And in federal court, with the exception of one case in the Eastern District that was decided under California law, every case in the Eastern District has ended up going up on appeal, and they're now sitting in the Third Circuit. They took the first 9 and then stayed everything else that came behind it. And those 9 consolidated appeals are now in briefs. And I kind of was predicting all along that those cases would go to the Pennsylvania Supreme Court on certified questions. But as you can see here, other circuits are deciding it. And so the Third Circuit may decide it as well. There is an error in this slide. There's only 4 federal circuits that decided this. When I was counting, I unfortunately counted, I think, the 6th Circuit twice, where there are multiple appellate decisions there. So 6th, 8th, 9th, and 11th have all decided this, and all of them have been consistent with what we've seen across the board in terms of insurance companies have prevailed. In Pennsylvania, as far as the court numbers go, Scott has, to my knowledge, 2 of the 3 cases that policyholders have won. Those 2 come with an asterisk because they were both decided by the same judge, and they're, of course, consistent with each other. I won a common pleas case in Lancaster County. that is now up on appeal and waiting for a decision, and also one in Lackawanna County. One of the proudest decisions that I got in my entire career, because Judge Nealon is a very tough customer. And the other decision that went for policyholders was one that was authored by Judge Nealon after I won the Scranton Club case in front of him. There are no cases in Pennsylvania, 0 cases in Pennsylvania where a policyholder has won in a published decision where there was a virus exclusion in the case. There are some large insurers who have policies that don't have an exclusion, but many, in fact, I think every one that I'm handling has a virus exclusion in it, and it's all in that standard form. And so really, I don't want to bore anybody with additional case updates, but that's the current state. And if you're going to take anything away from this, that first bullet point is the one I would like you to remember.
And when Kevin's talking, a couple more things I think are important to look at in arguments you can make when you're dealing with the exclusion. There are companies that offered pandemic coverage. One of the things we're making in some of the virus exclusion cases is that if there's coverage, why would some companies needed to have offered pandemic coverage if they already had a virus exclusion in their policy? That clearly there was an intent. And in fact, there's a case out of Texas where a movie theater actually purchased this pandemic coverage before COVID, and they're still getting denied because the insurance company's defense is that COVID is not referred to. It only referred to SARS and all the swine flu and stuff like that, which the argument is, well, if it's pandemic, it's pandemic. So I think it's important to read the policies and try to be creative. But the main issue is really going to be physical loss or damage. That if the policyholders are successful, it potentially opens up every policy. If the policyholders are not successful, then they basically 99 out of 100 probably go down. So hopefully our state Supreme Court will rule on that. I think Kevin's right. The Third Circuit consolidated those cases and the briefs are done. My anticipation is the parties are going to ask that gets certified under the Pennsylvania Supreme Court rule that the Third Circuit can ask for specific questions to be certified that are so they could decide the state law on that. The Ohio Supreme Court has already done that in Ohio, taken that circuit's decision. So hopefully it'll happen here. As far as making a claim, and then we'll open it up to questions to finish up. If you're thinking of making a claim or you're not sure, the first thing you need to get is the policy. And it may sound obvious, but it's, you need the policy that was in effect at the time of the closure. Also, when someone's calling the agent, make sure that a claim is open, because a lot of businesses had called agents or companies and the company said, well, there's no coverage. And then they just didn't do anything. So you want to make sure that you open the claim, even if it's going to be denied, ask for the denial letter. Potentially, and I don't think it's going to go anywhere right now, but down the road, look at consumer protection in the insurance department. But for the purposes of making the claim, you want the policy, the denial letter, and also keep track of the date. It's not on this slide, but most if you're going to sue the insurance company under a breach of contract theory, generally in Pennsylvania, it's 4 years. However, under these policies, most of the policies have coverage limitations on when you have to file a lawsuit against the company. An overwhelming majority are 2 years from the date of incident, not 4 years. And even some are 1 year, like Nationwide and Utica Mutual were 1 year. So if you're pursuing a claim, a lot of claims are going to be coming up on the 2 years in March. So unless you could get a tolling agreement or some other agreement, you may actually have to pursue the case a lot quicker, or at least file a writ of summons. So Kevin doesn't have anything else to add. I'll open up to the dean and any questions that anyone may have.
Do not.
I've got a general question is how long do the two of you think before we get closure on all these cases, and does the continuation of the pandemic with the different little surges and things we're having, will that make a difference in how quickly we get closure?
I'll let Kevin answer also. I think that from the plaintiff standpoint, the closure, but I think it's going to be at least another year before we'd have like a Supreme Court decision in the state. Although there could be a lot closure quicker. If the Supreme Court finds no damage or physical loss, then all the cases are done. If, on the other hand, they find coverage, then you have to get into the weeds of every claim and look at, was there a virus exclusion, was there not, what are the losses? Then you get into that PPP argument. In addition, if you're a company arguably that is entitled to coverage and there's no virus exclusion and we're still in a pandemic, the losses could still be accruing. It may be over, but you never know. So I think it could go on for years, but it also could be done pretty quick depending on how the courts rule.
Yeah, in terms of the time frame for a decision from the Supreme Court, a long time, a year, maybe even into the early 2023 till that is finally resolved, because it's got to work its way there and can't just jump. The ongoing most losses related to the pandemic are, I'm not saying none of them are continuing to accrue, but with the relaxation of government restrictions and orders, if the order is found to be a triggering mechanism to cause loss of use, virtually all of those orders have been lifted, and so I would say the worst part of the claims are over, but not that there wouldn't be some cases where they've gone on.
Yeah, I've got one question, and this is looking, is there a similar problem in business that could come up similar to the pandemic that might trigger another program? We have to talk about whether business interruption insurance covers it or not. I mean, the pandemic is interesting. I don't know, civil unrest, trucking strikes. I mean, are all those things kind of covered by the policies right now?
Well, I'm going to give you a great big it depends when I answer that question, because it's difficult to say in the abstract. I've been doing this kind of work for more than 25 years and handling property claims for that long. I think in one way, shape, or form, I'll be handling business interruption claims for the balance of my career, some related to COVID and certainly some that aren't. They're devilishly complicated, even in a non-pandemic context. Because if you've got many small business that are insured, that have varying degrees of quality when it comes to record keeping and trying to figure out what a loss actually is or what it amounts to, employees are paid under the table, lousy business records, those types of things make these expert intensive, even when they turn into covered claims. So it can be messy. The policies themselves are not, once you become familiar with the terms and how they fit together, I don't think they're that difficult to apply to certain circumstances. And frankly, it's my belief since the inception of this that it was as plain as the nose on my face that there's no coverage for these claims. But there has been a tremendous amount of intellect, creativity that's been brought to this, which happens whenever you have a disaster. Hurricane Sandy, you name it. The 9/11 disasters triggered a whole lot of litigation over these types of things and helped kind of define the contours of the issue that we're looking at today.
Scott, do you have any thoughts?
No, I agree with Kat. It really depends. Like you could have a riot. Like I know there's a case from Michigan from the 70s where they found that the Detroit riots were, a triggering mechanism for coverage for civil authority because they got closed down. So I think it depends on the circumstance. And I think what I found with businesses, like Kevin said, the bigger problem is on the back end is establishing what the losses are when a lot of these small businesses, because it's really like bed and breakfast, mom and pop, trucker, like people don't keep the best records until they need to keep the best records.
Yeah. We've got, I've got time. We got time for one technical question that I received over chat. And it's kind of a refinement. Do the time limitations to bring a claim under a policy begin when a pandemic is declared, or is in Pennsylvania after business were permitted to reopen, or depending on the payment terms? Is that a?
I think it's the date that your loss started, and then basically I think the companies, when you call and you say this is when we close down, and the thing is each county at the beginning of this initially had different closing dates depending on different circumstances, but I think the universal date most people are using is about March 10th or so. But I think the first, the latest date would be like March 17th was the first government order, I think.
Kevin, do you have a thought on that?
Yeah, and this is another thing where there may be some creativity in trying to argue that an ongoing loss gives you some later trigger date, but I completely agree with Scott that you do have multiple potential dates that might trip the start of the statute of limitations. The latest one of which is either March 17th or 18th, when the governor issued his first order. If you're taking a risk if you wait beyond that date to file.
The only case offhand, it has nothing to do with business interruption, that I could give anyone to look at on that our state Supreme Court's ruled on statute of limitations with insurance, is there's a case from a couple of years ago, Erie versus Bristol, by Madam Justice Mundy, where it dealt with a denial of uninsured and underinsured motorist coverage, but what she used is the date of the denial was actually the beginning of the statute, like where you knew there's a dispute. So I could see on something like this where no one's 100% sure, using that by analogy and saying, well, this is when you knew it was getting denied, this is when it starts.
Yeah, and I will agree with that too, but I think a lot of these claims, particularly one that wasn't presented in the March-April timeframe of 2020, those are the ones that are going to be more difficult. And Bristol, in my view, created an unworkable system that in a lot of underinsured motorist claims, there's no statute of limitations at all because the claim is never denied. And could there be a Bristol-like argument made here? Somebody will undoubt, well, you're looking at the guy that's going to make the claim, and it's not me.
The dean.
Not
No,
me either. So
it's not him either.
This has been a really unique discussion where we've had two of the top practitioners in the area, both who are actively litigating these issues, have, come together and have had a very civil and helpful conversation on the parameters of this litigation, what's going on, what the arguments are. And I think it's been absolutely terrific. And I wanted to thank both of them and to thank all of you. And please keep monitoring our websites. We'll have hopefully more programs similar to this one in the future. So thanks to everyone for attending.
Thanks, everyone.
Thank you.